Good evening, everybody. Hope you are all doing well. This is Jonathan Ginsberg, and it is July 8th, 2026. Again, I hope you are all doing well and you had a very nice July 4th, meaningful July 4th. We went to a local July 4th parade, Independence Day parade. Took my granddaughter, had a very nice time there. And it was, kind of neat to see some of the patriotism. People are I think that's something that's been missing a little bit, and I think it's not a bad thing to have. So, anyway, I hope you all had a good one, and I hope that your summer is going well and you're staying cool. Let's jump right into the comments here. We have one of our regulars, Hakasad, who's basically said, asked about the feeds. And I put this on here because when I set this up through YouTube, and basically I set this up to syndicate at YouTube and LinkedIn and Instagram, Substack now. Some of them allow you to choose to have it as a landscape, and some people say, and some you can have it as landscape or portrait. And portrait would be like Instagram, where it's being done on your phone, so it's vertical, versus a landscape, which is on your computer. So it's the same feed. It's just one of them is going to be landscape, one of them is going to be portrait. So that's why there are two. So choose the one that's most appropriate for how you're viewing this. Okay. Please read to the end. Would you really appreciate your insight? Obviously, I'll contact the OHO, Office of Hearings and Operations, which is the hearing office. The portal shows the hearing update. What could be the reason? Why wasn't there an alternate date set? Okay. On June 24th, 2026, the ALJ postponed or canceled your hearing scheduled for September 26th. If it's a scheduling issue, why not just set a new court date? The notice provided no additional information. Also from this line from the notice, I didn't request it. No further postponements will be granted unless you have compelling reasons. This is from the ALJ. Let's see. So it looks like it's the same. I guess you put the same question in both the landscape and the other one format there. All right. So basically what's happened is Hakasad got a notice from the hearing office that his hearing had been rescheduled or postponed. Why would that happen? There's a couple reasons. One would be, the positive would be that the judge decided to approve his case on the record. And that has happened to me a couple of times where I'll get a call from the hearing office saying the judge is going to approve your case, no need to have it, and they cancel the hearing. But normally if they do that, they'll tell you that's why they're doing it. They're going to agree to approve your case. A second thing that's happened to me has been that the judge had a scheduling conflict, meaning that the judge either had scheduled time off or is having surgery, or there's some other scheduling conflict either with the judge or the hearing office. They can't get a vocational witness, although again, if it's not set for September, that would be kind of odd. It's strange to me the hearing office can't tell you. And I think what I would probably tell you to do is call the hearing office back and ask to speak to the judge's assistant and just say, look, you need to tell me what's going on here. They postponed my hearing. What is the reason for it? They need to tell you that. If they won't, I think I would reach out to your U.S. Senator's office and say exactly what you told me, is you had a hearing schedule, you've been waiting for a long time, they postponed it, and they won't tell me why, and I want to know why. And the whole line about no other postponements will be granted, that's just boilerplate, because usually when a postponement is done or is acknowledged or agreed upon by the judge, it's because the claimant has asked for it. For example, I had a case not too long ago where my client had been in the hospital, and a week before the hearing, she was still in the hospital and in no condition to testify at the hearing. So I reached out to the judge and I said, my client's in the hospital. I submitted some documentation, asked for a postponement. The judge agreed to it. So that sort of thing. And then they, of course, send you a letter saying no other postponements. But of course, if you have another compelling reason, they'll do it. I mean, obviously, judges don't want to continuously postpone cases just because, people are, they're going out of town on a vacation. They're not going to do it for that. But if it's because of an illness or a death in the family or something like that, that they might. But I think here it's odd to me that they're not telling you why. I think if you kind of go beyond the hearing office, switchboard, and you ask to speak to someone in the judge's office, a assistant or something, that might help you. Or and if you can't get them to do that, then that's where I would have your U.S. representative or Congress or senator reach out and deal with it that way. Kevin says hello from Tennessee. Grandpa Panda. I was on grandpa duty today. Wednesdays, my wife and I get my granddaughter, my now 3-month-old grandson. So I had grandson duty. And 3 months, they don't do a whole lot. But he's looking around a little bit and he's interacting a little bit, giggling a little. But you don't really know what he wants. I mean, he wants to eat a lot. Of course, I do too. But it was a long day, and then my granddaughter was her usual precocious self. Came home for lunch. My wife brought her home for lunch, so it was a long day. But that's what it's all about. What in the world? I mailed and updated a functional report, but received a letter that was never received. I sent them a fax today. Does this happen often? Yes. Unfortunately, it is not uncommon. I think one of the things you want to do to help avoid that, and basically what's happened is you uploaded a functional report. You didn't really say how you uploaded it. Was it done by fax or email or how it was done? Normally, if you're not represented, it'll be done by fax. The key here is you want to ask Social Security for a barcode, which is a piece of paper that's got like a barcode you'd see at a grocery store that associates that document with your file. And it should be automatically associated. If you don't have a barcode, you're depending on Social Security to figure out who you are and where it's supposed to go, and stuff gets lost. One of the nice things about the way I do it as an attorney is I'm able to upload things directly through the Electronic Records Express, which you can't do. They make it really hard to get qualified for that. You got to go through a class and all this kind of stuff, but that's only really for representatives. But we can upload it directly. So when I upload, let's say, a brief, I upload it, I'll see it there 10 minutes later. Or 5 minutes later, right away. But if you're doing it by fax, it may take a couple of days to get processed. But if it's been a while, a day or two, it's not showing up there, then I would probably ask for a barcode and resubmit it. If you have to submit something a couple of times, they may get upset about it, saying you're making extra work for us. Like, well, you're not showing it was received, so I'm going to keep submitting until you show it's received. But yeah, I think that's an important thing to do. But I think the barcode would go a long way to help make that work. Suki Glass, will there be a CDR this September? In September, it's my 7th year in SSI. I've done a CDR in 7 years. How can I know? Can I call my field office? I think that with CDRs, traditionally what the issue has been is that Social Security doesn't have the staff to really do it. Now, they changed something a few months ago where they're centralizing the CDRs, or continuing disability reviews. It'll be centralized at the federal level. So instead of relying on the states to do it, the state DDSs, the Disability Adjudication Services, it'll be done at the federal level. I suspect we may see more of them. Certainly Congress is pushing Social Security to do more of them. Why? Because they want to get people off Social Security, disability. So, it's possible you'll get one. I'm not a big fan of calling them to ask for it. Why? I mean, it doesn't benefit you. I mean, the best case would be that they do a CDR and decide you remain disabled. But, the worst case would be they decide you're not disabled. But why call them and say, evaluate me? It makes no sense. It's just you're asking for trouble. So I think no news is good news. As I mentioned before here, if you're in a 7-year review, that's the one that's least likely to be reviewed. If you're in a 1-year review, you're going to be reviewed. A 3-year, you're going to be reviewed. 5-year, maybe 7-year, it's because they've decided that medical improvement is not likely. So they're not going to waste their time with people where medical improvement is not likely. So therefore, I would tell you, let them come to you. Don't volunteer anything to them. That's my opinion. Now, again, if it makes you feel better to call them and to ask them, go right ahead. They may not be able to tell you, because I think that it's going to be done. If you call your local office, they may not have access to what's going on at the federal CDR office, and I don't know of any way to reach out directly to the federal CDR people to find out. One thing about CDR is just let me try to get this out of my throat. Okay. One thing about CDRs that's difficult from my perspective is Social Security makes it really hard to get an attorney involved in a CDR. And the reason for that is if they send you the paperwork for a CDR, it's basically like a form, and you could hire an attorney to help you with it. But quite honestly, it's really not that hard of a form to fill out. Just fill the form out and you submit it. But if they decide they're going to terminate you, they send you a letter saying, we think there's been medical improvement or there's evidence of work. We're going to go ahead and move to terminate. And at that point, you have a choice to get an attorney or not. You also have to make a decision within 10 days. Do you want benefits to continue while you appeal? So if you choose to have benefits continue, and it used to be they didn't even give you a form. I think now there's a form, but you got to get it in really, really quick. And, sometimes the mail takes a few days. Maybe you have to fax it in to get it in quickly. And I've heard situations where people wanted benefits to continue, but they couldn't get the form in on time, and benefits got terminated, and there's no way to really appeal that. It's a big mess. And 10 days is just not enough time, given that the mail, they assume 5 days for the mail. So 10 days is not that long, and the mail, it happens not infrequently where the mail gets lost or delayed, and you don't even find out about the notice of termination until 2 weeks or 3 weeks later. But set that aside. If you choose to have benefits continue, you continue to get your monthly payment while you appeal. The problem is if you call a lawyer and say, okay, I need some help with the CDR, which is in essence filing a reconsideration and then going to a hearing, there's no past due benefits. Your benefits have continued, so no benefits are accruing. So if you talk to a lawyer, the lawyer is going to say, okay, you need to put $4,000 or $5,000 into my escrow account, and then I'll bill off of that and file a fee petition. Well, A, most people don't have $4,000 or $5,000 to put into an escrow account. And B, fee petitions are a major headache for lawyers because Social Security doesn't put any emphasis on processing them. I have some that have been out there 6, 7, 8 years, and they don't touch them. And it's just you call and you call and you call, and then all of a sudden, at some points, money shows up in your account because somebody finally looked at it. But it's not a way to do business. And I'm at the point in my career where if somebody was to call me and say, okay, here's the case, but you got to do a fee petition, I'm probably going to tell them no, because I just don't want to go through the hassle of doing a fee petition and having to wait years to possibly get paid. And sometimes they don't pay you at all. And sometimes judges will, cut the fee you requested in half. I mean, it's really pretty brutal. Big problem is that if you don't choose to have benefits continue, then you're going to have trouble finding a lawyer, because you're going to have to get a lawyer who's going to do a fee petition, and you got to find somebody who is who you can afford to put money in their escrow account, because I think most lawyers would tell you that people on Social Security don't have a lot of money, obviously, not that you want to sue anybody, but they're judgment proof. And if you say, okay, well, pay me if we win, they're not going to have any money then, because they're not going to get a lump sum. They're just going to get their own same money they're getting. And so, it's just, as a practical matter, you're not going to get paid. If you choose not to have benefits continue, then yes, there will be accrued benefits. But the question here is it winnable? If they cut you off, there was a reason they felt they wanted to cut you off. Maybe it's not a legitimate reason. Maybe they said you improved medically, you really didn't. And the attorney, you can, the attorney will say, okay, I believe in your argument. I'm going to go ahead and take the case, and we'll get paid if we win. But if it's because you were working, or because there was, some medical improvement, but it's a question about how much, or a combination of those, it may be difficult to say, well, there's enough of a chance here to win. I actually did an article on Substack today. been on it for a while. I've never really written anything for it. And I did a little article about kind of what I look for in disability cases. And, one of the points I made in that article, and I'll share it with you, is Social Security creates a disincentive for lawyers like me to take on difficult cases because, there's certain things that, make a case really hard to win. If there's drug and alcohol use, if a person is under 50, or especially if they're under, let's say, under 40, really difficult to win. If they've got an invisible illness like, migraines or depression or anxiety or PTSD, really difficult to win. If they can't afford to go to the doctor, hard to win. Some of those folks have legitimate cases and they are truly disabled. But you look at it and you say, what are the odds of me winning this case? You hope you draw a good judge with a really high approval rate. But if you don't, you're probably not going to win. I remember one of my colleagues made a comment at a convention, I think, that, those cases with certain scenarios, they should allow attorneys to charge a higher percentage, or there should be some mechanism to get paid so that people have, with difficult cases, have at least some shot at getting an attorney to represent them. But if Social Security makes it, where you get paid the same thing, whether it's a case that's, 57-year-old with 3 herniated discs or a 43-year-old with really bad PTSD, one of them is a really good chance you're going to win. One of them is going to be a real, question. Why would you take a case where you're most likely not going to get paid? You're going to do 2 years of work and tie up your office staff. And there's just a disincentive. I mean, I would even go so far as to say that on certain situations, I don't know how they could do this, but there should be a fund where attorneys get paid something. I mean, if you could, okay, let's say that, your normal fee in a disability case is 25% with a cap of $9,000. Most people are going to tell you the fee they generate is $5,000 or $6,000, on a winning case. If there was some sort of a fund where you take on a really difficult case, and that had to be defined in a certain way, but there was $1,500, $2,000, almost like what public defenders would get, but for taking that case, and you could have people that otherwise couldn't get an attorney, there would at least be some mechanism to get them paid. If they win, they get the higher of the contingency fee, but if they lose, they get something. They have something like that at the federal level called the EJA, Equal Access to Justice Act, where if you take a case to federal court, you can ask for EJA fees that are paid by the government to encourage people to get lawyers to handle these more difficult cases. I'll get off my soapbox, but my point is that there's a disincentive, and I think the CDRs are a perfect example of people who really need a lawyer, but they have to make this choice. Okay, I can maybe get a lawyer if I choose not to have benefits continue, but meanwhile, I'm going to wait for 1.5 years with no money coming in and hope I can get a lawyer, or I'm going to choose to have benefits continue so I can buy food and go to the doctor and medicine and gasoline, but I'm not going to be able to get a lawyer, so I'm going to go in front of a judge by myself. Makes no sense, but that's the situation. So, it's really hard to get an attorney to do a CDR. A cynic, like my guest from the other week, Spencer Bishens, would say that's by design. I'm not sure if I quite go with that, but you got to ask yourself, why do they make it so difficult for people to, get representation for a CDR? So anyway, Suki says, thank you. Thank you very much, Suki. Thank you for tuning in. This is where I answered Hakasad's question about the live stream. Hello, Bala. We have our hearing coming up next week, and I think we are ready to go. The brief turned out really well, and I think we got a good judge and we got a good shot. So I'm looking forward to getting that taken care of next week. Dimple, hello, Dimple. How are you doing? Jody Maxwell, how do you get off chat to comment so I can ask questions? Well, I mean, just chat is the way to do it. I mean, I don't, honestly, I've never been on my own live stream. So you're not really, I guess, I'm not sure if chats or comments are very different, but what you just did, you asked me a question. That's how you would ask a question. So however you just did it to say, how do you get off chat? Do the same thing to ask your question. Okay. DIDS. All right, Kathy, that would be a question that I cannot answer because I have no idea what you're asking me there. Would talking your Social Security benefits hurt your disability case? Would taking, maybe you're asking. So if you're saying, would taking retirement benefits hurt your disability case? Look, the answer is no. I mean, if you take your retirement Social Security, which is based on your age, that really has nothing to do with whether you're disabled or not. And I don't think that judges would look at it and say, well, now you're on retirement Social Security, therefore it's less drain on the disability trust fund. That's not going to happen. Um, the practical question is, if you, let's say you're 62 and you start taking your retirement benefits, and then you file for disability at the same time, what you're going for is essentially the difference between the early retirement and full retirement. You don't double dip. So let's say, for example, your early retirement is $1,500 and your full retirement or disability, they're about the same, is $2,000. So if you take your early retirement, you got $1,500 coming in automatically because you're 62. What you're going for is that $500 extra to bump it up to full retirement and to possibly get earlier access to Medicare. And sometimes there's a year or two where you're getting disability and then it kind of goes to the partial because it's, the difference between the two. But I've had people call me that they filed for disability, they took early retirement, because when you're 62, the form will ask you online, do you want to go for early retirement now at the same time? Because you're eligible for it. So if somebody called me and said, okay, I've taken early retirement, but the difference between early and full or early retirement and disability is $200 a month, I'm looking at it saying, okay, so let's say that it takes, 2 years. Maybe they're looking at, depending on how much their benefit is, $4,000, $3,000 for, 2 years of work. So 25% of that may be $800, $1,000. I may not take that case because, quite honestly, the amount of work I'm doing is the same I'd be doing for a case where I might generate $6,000 or $7,000. And again, I have a limited staff with a limited amount of time. You're only going to take cases where you can, justify the cost. You don't want to lose money on cases. And I hate to make this seem so economically driven, but I mean, the reality is that, in a small law firm, I have a certain number of people that I employ, and, we have a pretty efficient system. We try to make it more efficient, but everybody's busy. And so you're working on a case. If my paralegal is working on a case, she's working on that case, she can't work on another one. So if she's working on a case that's going to generate $1,000 for 2 years of work, means that the case is going to generate $5,000 for 2 years of work, doesn't get worked on as quickly. And, at the end of the day, my cost of doing business, when you factor in rent and electricity and computers and copiers and staff, if I only make $1,000 on a case, I'm probably losing money because it costs me, when all is said and done, more than that to process a case. So, this is a reality, and it's hard to talk about it because I don't want people to think, and I know my colleagues feel the same way, this is all about money, but I mean, you don't get rich doing Social Security disability. Realize that the cap is $9,000, sounds like a lot of money compared to a personal injury lawyer who settles a case and can generate $100,000, $200,000, 50 grand, one case. This is volume. You got to do it in volume. You got to be real selective of what you take. And, sometimes, as I was just saying, people with the biggest problems, have the cases that have the least chance of recovery. And, sometimes you take them as sort of a pro bono, but you can only do so much of that because you got to keep the lights on. So that is what it is. Okay, so Bala, who again is my client, said she uploaded her documents using the My Social Security portal. This is in response to somebody who's talking about a form that they uploaded. And I think that's a good way to do it because the portal is an electronic way. I still like the idea of having a barcode. So I think that would be a good thing to do. But hopefully you can get that figured out. It may take a couple of days before it shows up. And you have to figure out where it's going to show up because until you're at the hearing stage, you're not going to see what they've got. And one thing Social Security doesn't do a great job at, in my opinion, is they don't make it available for individuals to see what documents have been uploaded in their case. When I'm looking at a case, I use these utilities, these little programs, online programs. One of them is called Chronicle. One of them is called Assure. They're really the same thing, and I probably should eliminate one of them, but I still use both of them because they both have some unique features. But I could log into Chronicle and I can see if any client I've got at any stage that has got my notice of where I've uploaded my notice of appearance, I can see what's going on, what documents have been received, what they're doing, what requests have been made, kind of in real time. And that's a real help, because if I upload something and I see it's not there, which never happens at this point, but I can re-upload it. Or if my client says, "Well, I uploaded a medication list, but it's not there," I can see why it's not there. At least I can see it's not there. We can know to upload it again. So, Social Security, I think, needs to do a better job of letting people have access to their own files. They don't do such a great job with that. Cynthia says, hello, Cynthia. Chan Ted, hello, Chan Ted, another regular here. Jody Maxwell says, I have my phone hearing on Friday. You are 60 years old and I've been waiting for 2 years. Isn't that outrageous? It's just crazy. People wait for that long. It's very typical. Your attorney says the judge has all my doctor's appointments and problems. We just have to tell them why I can't work. Brain fog, among other things. Well, realize and let me just kind of address this more in a holistic way. The issue in a disability case is whether you have a medical problem. They define disability. Social Security defines disability is, do you have a medically determinable impairment that has lasted or is expected to last 12 consecutive months or result in death that prevents you from engaging in substantial gainful activity. Substantial gainful activity being $1,690 a month in 2026, which is about $21,000 a year. So it's a pretty, not a lot of money. Or an activity like, volunteering someplace, working in a museum, being in school, watching your grandkids, watching an elderly relative, that is equivalent to, a job that you would be able to make basically minimum wage at. So it's very much about vocational capacity. So yes, this is about why you can't work. I think brain fog, in my opinion, is a little too general. I think the way you want to look at this would be break down what a job requires, both physically and cognitively or mentally or emotionally. So physically, if your medical condition impacts you in terms of standing, walking, sitting, lifting, carrying, kneeling, stooping, crouching, crawling, bending, reaching overhead, engaging in daily activities like bathing or dressing, things like that. Are there physical issues that you have to deal with that your medical condition prevents you from doing? So if you have documented herniated disc and you're reporting to your doctor that you have shooting pain going into your leg, and 3 or 4 times a week, the pain in your lower back is so severe that you cannot focus and concentrate, and you find yourself in a recliner, and that you need to take a 2 to 3 hour break during the day to lie flat to get the pressure off your back, that is how you argue that you are disabled, that you wouldn't be a reliable, dependable employee. And if the judge accepts that in the question to the vocational witness, which is going to, person will be at the hearing, professional witness, the judge says our hypothetical person is going to be off task for 3 hours a day, or maybe they even discount it a little bit and say 2 hours a day because of chronic pain, needs to be in a recliner, not able to focus on work at hand, or medication side effects or pain or whatever the may be, but for 2 hours a day, 3 days a week is not able to function, then a vocational witness will say that would preclude all competitive employment. That's what you want. If a judge says the vocational witness, we have a person with brain fog, what does that mean? Does it interfere with attention, focus, and concentration? Theoretically, you could do a job if you had no physical impairment and you had a little bit of brain fog. If I gave you a job where you're basically sitting there and you're putting, ink pens in a box, one after the other, day after day, you could have brain fog, not be able to focus and concentrate on anything substantial. But if you're doing the same thing over and over and over that a robot could do without any sort of, cognitive issue or you having to think or change your routine, you're not disabled. So I think if you're focusing on, cognitive issues, first of all, if they're physical issues, I tend to like those because there's typically an MRI or a CT or some objective test, broken bone or something that ties the complaints you've got to your physical limitation. Whether that's the case or not, now we get to the cognitive, mental health, emotional. You kind of go into a different set of questions, maintaining attention and concentration, appropriate persistence and pace of work, behaving in an emotionally stable manner, not being distracted, things like that. And you and your attorney should go through all of those things, which you can probably find in a mental functional capacity form. And I think I've given you these before, but let me pop them up here for you. There are a number of places you can get free functional capacity forms. And I need to put these in a better place because I'm always having to look for them as opposed to just give you. I know there's a lawyer. Okay, here we go. Here's one. Mike Marburg has some on there. I don't know him, but he's got to put them on his website. But here's another place you can get some. There's one place you can get them. Let me give you the other. And just get a mental functional capacity form. I can't find it off the top of my head here. I need to really put these in a different place because it is. All right. Anyway, I can't keep my hands on it right now. There's a guy named Mike Marburg, Marburg. Look him up, and he's got some free forms on his site. But if you look at a mental functional capacity form, let's just pull one up here, and I'll show you what it looks like. Okay, so let's do a screen share so you can all see what I'm talking about. And this is kind of what I would use in prepping for my. Oh, that's not what we want. Here we go. Okay. All right, so this is a form from that site I just gave you. This is called a mental residual functional capacity assessment. And what that means is that your capacity to function in a job is your capacity. And so if it has been eroded or reduced by mental health issues, then what is left over, what you've got left to work with, is residual. That's what residual means. So if a doctor fills this out and says, okay, this is what my client's mental residual functional capacity is, that's telling the judge this is what this person has the mental capacity to do. So if you look at the form, if this is filled up by your doctor, they would have a diagnosis, and they use this called Axis 1, 2, 3. This is there's a mental health guidebook, DSM, I think is what it's called. There's like version 4, version 5, but they typically would have a certain title for, PTSD, major depression, recurrent, severe, different titles for different types of mental issues. And ideally, you want a specific diagnosis. A GAF stands for Global Assessment Functioning, or Global Functioning. And I think if it's below 50, it's pretty bad. So this is where a psychologist would assess your GAF. If it's 35, that means you're having difficulty kind of dealing with basic daily activities. So again, this is what they put on there. But let's just kind of go to how to prepare for the case. So, when you're looking at your mental capacity, understanding and memory, ability to remember locations and work-like procedures. Is it mild, none limitations, mild, moderate, marked, extreme, not rateable? So if you start seeing a lot of marked or extreme, or a lot of moderates and a few marked, remember simple, short instructions. If you have marked limitations there, that's probably going to look like it may disable you from a lot of jobs. So if you have a lot of these, carry out detailed instructions, maintain attention and concentration for extended periods, work within a schedule, maintain attendance, sustain an ordinary work routine, work in coordination with others, make simple work-related decisions, complete a workday without interruption from psychologically based symptoms, ability to interact appropriately with the general public, coworkers, supervisors, ask for assistance. You can see all these kind of things. And what I would do, if I have a case where it's mostly mental or cognitive or emotional, I'm going to go through something like this and ask my client, and we'll come up with questions to get that. So, For example, if I'm preparing somebody, I might say to them, do you have trouble completing tasks? Give me examples. Yes, if I try to plan a dinner, I'll, get all the ingredients together. I'll put one thing, I'll get a pot of soup going, and then I get frustrated, or I lose track of time, or I get distracted and it burns and I don't get anything else done, or I can't keep, three different things going at the same time, or I need help, have to leave myself notes to remember to take my medicine, or to clean my house, or to take a shower, things like that. I rely on other people to help me with basic activities of daily living. I have difficulty interacting with other people. I've gotten on verbal altercations with people at the bus stop. I think people are looking at me and I get really angry and I confront them. I'm confrontational. And sometimes I might have a third party, a spouse or a relative come in and say, yeah, my mom, she'll think people are looking at her, and she'll just go up to somebody and start yelling at them. That's the sort of thing employers aren't going to really tolerate, right? So that's the sort of thing, memory. If you just can't remember, simple things, you're easily distracted. So I would come up with questions that would yield answers that would suggest marked or extreme limitations in these areas. So brain fog, it suggests that you don't think very clearly, but I would break it down further to, do you have trouble remembering simple things? Do you have trouble doing repeated tasks, the same thing over and over? Do you forget, the order of things, simple things? Have you ever, silly example, you got in the car, driven to the grocery store, and realized you left your wallet at home? Did you made a grocery list but left it at home? Or you went to the store, you had a list and you bought, of the 15 items, you bought 6 of them and you forgot about the other ones. That may be an example of somebody who has, too easily distracted memory loss. If it's a PTSD case, a person says, I go to a restaurant, I've got to be at the very back of the restaurant where I can see everybody walking in, or I've got to be near a door. Any loud noises or flashes of light set me off. And whatever the situation is unique to you, but that's what your attorney would be able to do, is to help you give examples of those things and define it more clearly as to what the brain fog means, and really relate it to how that brain fog would make it all but impossible for you to be reliable at even a simple job. Now, if there are physical issues at 60, Jody Maxwell, you may have the grid rules that could come into play, and that could give you a real advantage. And the grid rules, I've got a website called gridrules.net where I talk about that, but basically it makes it easier to fit into the disability definition if you have physical limitations, and makes it more difficult for Social Security to say there are other jobs you could do. So if there are physical issues, that would be something to address. But I think that you and your attorney should have a discussion about, the questions that you're going to be asked. I actually go over the questions, and many times I'll send my client the notes as to what I did, and I've got a handout I give them what the questions are like. That it gets too long right now, but I'm working on cutting it down a little bit. But practice those questions and practice answering them, so what makes sense. I remember I've had cases where client with badly herniated discs, I'll say, well, how long can you stand? Oh, about 2 hours. I'm like, 2 hours? That's a long time to stand for anybody. But if you've got herniated discs, doesn't it cause you, oh yeah, well, I got to lean on something, I got to sit down. No, I'm saying if you were in a work environment and and doing it day after day, how long could you stand? Oh, about 10 or 15 minutes. Big difference in 2 hours, but you want to get that knocked out before the hearing during your pre-hearing call. Okay. Cynthia says, we watch our grandbaby. Yeah, we watch them once a week. And yeah, it's very, let me cancel the screen share here. It's very rewarding. It's a lot of work. And, I kind of don't even remember when my kids were that young. It's kind of a blur, but it's kind of neat. I mean, I'm fortunate my kids both live near me, and my grandkids live about a mile away. We see them all the time. So it's a blessing in that regard. But it's, both my wife and I are attorneys. We go 100 miles an hour, and then Wednesday it comes to a screeching halt, and it's hard. It's really, I get up early and try to knock out some things before then. And, we both agree we're not going to do any work when we're watching the kids, but, the phones ring and people call. I was, this morning I was, feeding one of the kids, and all of a sudden my phone rang. I had an old client who had my cell phone number, which I really don't try to do that, but this person had it for a long time, and she's a nice lady. And she's like, I got this question. She starts, I said, hold on. I need to redo this for tomorrow. I can't talk to you right now. I've got grandbaby duty, and I'm not going to talk about a complex legal matter at this point. So yeah, it is a change, but it's kind of cool. So if you have grandbabies, I recommend, while they're young, spend as much time with them as you can, because you know what, you can't get that time back. And I've read in basically, online, if it's on the internet, of course, it's got to be true, but I've read, from various knowledgeable resources that, the time you spend with your grandbabies, A, it's good for them, gives them a real sense of security, and B, it's good for you as the grandparent to, interact with them. It's healthy for everybody. So that is the deal. Jody Maxwell, thank you very much. I really appreciate that. $4.99. It was unnecessary, but thank you very much. I tell everybody what I do with that is my son, who's my video editor, he and I will go to lunch, and guess who pays? I mean, obviously I'm, I always get, paying, and he's actually pretty good about it. I will say he'll offer to pay, and I usually don't take him up on it unless I'm mad at him for some reason, but normally I pay. But this goes into the Jake Ginsberg Lunch Fund. So, Jody Maxwell, on behalf of Jake, myself, thank you very much. Yes, thank you very much. Okay, I hope I answered your question appropriately. Richard Pauly, I have to go and see August 8th to see a subsecurity doctor. Okay, so basically what Richard is saying is he got a notice that on August 8th, he has a consultative evaluation. I think that is what Richard is asking. And they're going to do some testing. If it's psychological, they'll do some psych testing. If it's physical, they may do some, neurological basic testing. Although the physical ones, they don't do a lot of testing. Maybe they do an X-ray. As far as results, they don't send them to you. Now, again, as an attorney, I can log into my Assure or Chronicle. I can download it and get it for my client. I've heard some people say you can contact Social Security and they will send you the test result. And certainly in your hearing prep, you'll see it then. But, you don't necessarily get it right away. Now, what happens is that report goes back to the adjudicator, the claims specialist who's working in your case, or the DDS, the state agency office. And the adjudicator will then look at it, send it to a medical expert they have on their staff, along with other medical records. And that medical expert will make an evaluation as to the nature and the degree of impairment you've got. So the adjudicator will get it pretty quickly. How long it takes the medical specialist to get all the other records to do the review, that could be a couple of weeks, it could be a couple of months, it could be 6 months. So there's no definitive timeline as to when that's going to happen, but the report will be in the hands of the adjudicator within a couple of days is typically what they do. And usually, because I look at these reports all the time, usually they're dated the day or the day after the examination. So if you were examined on July 8th, that report from July 8th or July 9th will be submitted electronically to Social Security, July 8th or 9th. It's pretty much immediate. So Jason is in the court stage waiting for a hearing date. So you've requested a hearing. Normally, I'm getting hearings about 7 or 8 months after the time I request them. It's usually pretty quick, so that's not a bad thing. Recent diagnosis of scoliosis. Well, Jason, scoliosis is a diagnosis. You don't win a disability case in a diagnosis. 2 comments. One is, how bad is it? I mean, does it impact your organs? I've had scoliosis cases where people's liver and spleen and, kidneys were being impacted because it was so bad, or the level of discomfort was so bad they couldn't function, couldn't concentrate. So A, how bad is it? Is this in addition to other back issues that makes those more complicated? That could be a factor here. And you said I was recently diagnosed. Now, when you applied, I'm assuming you didn't have that diagnosis. There were other things you based it on. So you got to be careful in that you don't necessarily want the judge to say, okay, I'm finding you, Jason, disabled now as of your scoliosis diagnosis, but not as of your original onset date. Now, that's an argument or discussion you and your attorney need to have, because sometimes it makes sense to change the onset date. So if you, let's say, turned 60 or 55, a month or two before the scoliosis diagnosis, you may say, well, let's amend the onset date to that birth date, and we can argue that the scoliosis obviously existed before then, or push it back as far as you can, especially if you have a low percentage approval judge. On the other hand, if the scoliosis is making things worse, you make the argument, no, my disability dates back to 2023. The scoliosis, which obviously existed back then, is part of the reason why this bulging disc is so symptomatic. It's just how you frame the argument, but that's what I would do. JG, that is me. Hope you're doing well. This is God Be First Revali. Okay. GE in Arizona. How does SSA or DDS look at varying opinions from doctors? If an applicant had 3 doctors look at, let's say, a lumbar issue, you probably get 10 different opinions. Well, realize that DDS is working as an agent of SSA. So while it's not the same thing, it's the same rules. So I think that, to answer your question, it's actually a very good question. So I appreciate that. I think that they will try to resolve the conflict, meaning that if you have different opinions from doctors, the medical specialist at the state agency level will make note that there are different opinions from different doctors, and then decide which one they think is the most compelling. Usually, at the state agency level, they're going to choose the one which has the least amount of restrictions. You get to a hearing and you make an argument as to why these other 2 opinions were not persuasive. Example would be you went to a consultative evaluation, and the consultative doctor decided you could do medium work, which is lifting 50 pounds occasionally and 25 pounds frequently, and standing 6 hours a day, standing and walking 6 hours a day. That's what the consultative evaluation is. On the other hand, you've got your family doctor who's known you for 30 years and your orthopedic surgeon who are saying, no, you're limited to light or sedentary work, or no work at all, or you're likely to miss 5 days of work a month. Okay, I would argue that the specialist, the orthopedic surgeon, or your longtime family doctor has a better, more accurate understanding of what's going on with you than the one-time consultative doctor who saw you for 30 minutes a year and a half ago. So you can make an argument, a qualitative argument, as to why some of these other opinions should not be given very much weight. But yeah, that's a conflict that they have to resolve. As an attorney, I'm obviously an advocate for my client. I'm trying to resolve it in a way that's most beneficial to them. But at the same time, I realize that if I've got opinions against me, I may agree with them, but the reality is I may have to concede, or recommend to my client, is a better way to put it, that we concede some past due benefits to get past that unfavorable opinion. Example that comes to mind is I've had cases where people were, had substance abuse issues and were actively using, and then they went to, Alcoholics Anonymous. They went to, a 7-step program, 12-step program, and they got clean. But they didn't get clean until November of 2024. And the original onset date was, September of 2022. I might say to my client, look, the drug use is a real problem until you got clean. And I think it's clear you're being tested. You're clean as of November 24. We might want to think about offering to the judge that we'll change the onset date to sort of take that out of the equation. And if we do that, the judge might appreciate the fact that it makes his life a little bit easier, and it might turn a marginal case into a winning case. That is just, that's kind of using experience. It could also depend on the judge. You have a really low paid judge, I'm going to push that. If it's a really high paid judge, so let's see what happens. Just be aware the judge may ask us to do this. And if they do, what do you want to do? But let's not volunteer it. So it just depends on all the circumstances of your case. But answer your question, they have to reconcile those things, those different opinions, and you want, as you or your advocate, your attorney or representative, want to argue for the explanation that is most beneficial to you, that makes the most sense to your argument for disability. Dolphin says hello from California. Hello from California. Baxter Taylor. I have my month before my illness paperwork. Should I submit it as medical? So I think what you're asking is, you have paperwork that dates back to the month before you became ill. I don't think there's ever a problem submitting something if there is reason for it. If I'm reading your question correctly, reason you would submit this paperwork would be to show that your condition went from stable and okay to unstable and disabling as of a certain date. And this gives context to that you were not, you were functionally not disabled before, but afterwards you were. That shows the difference. I think that's perfectly legitimate. For example, if you have blood test results that show perfectly normal, liver function tests, let's say, and then after some, you have COVID, let's say, or you have some other, infectious disease, and then 2 months later, your liver enzymes are just all over the place, and you're, on a short list for liver transplant, that earlier record would be very helpful. So the point is that if there is a reason to submit it. Otherwise, medical records that shows nothing wrong with you is not going to really help you. But if it gives context, then by all means. All right. Michelle says, when SSDI turns into Social Security at full retirement age, can I switch to my ex-spouse's benefits? Being an SSDI does not prevent me from getting that later. No, it does not. Your right to claim on your ex-spouse's benefits at retirement age, and I don't deal with retirement Social Security, so the rules on that would not be reduced or eliminated because you're on disability. It doesn't have anything to do with it. Okay, thank you, Bala. Appreciate that. That explains where the live chat is. And like I said, I've never been on my own live stream, so I don't know what it looks like. I probably need to. I don't know how I do. Maybe I'll jump on Stephanie's one time and sort of see what it looks like as a viewer. Stephanie Joy goes live at 1:00 on Wednesdays. Uses the same software I do. She was on last week. Good friend of mine, and I've been on her live stream, but I've never actually observed it as not being a guest, just because Wednesdays I got grandkids, but I can jump on for 5 minutes and see what it looks like. Okay. Cass 8920. I'm filling out paperwork for my last disability hearing. I failed 3 times. This is my last run. How does your illness affect your ability to work, is the first question. How do I not sound weak? So I'm guessing what you're saying is you've had multiple hearings and your date last insured is probably running. And, the judge is going to ask you, how does your illness affect your work? I think what you're asking is, how do you create an elevator speech? This might be a time where you ask like a Chat GPT or a Claude or Perplexity, to help you come up with an elevator speech to describe your illness. I think that you want to be, very specific. First of all, you want to know the date you were diagnosed. As your Honor can see, I was diagnosed with, let's say insulin-dependent diabetes in, 1995. I've been on insulin ever since. I've had increasing trouble keeping my A1C under control. At the time I stopped working in February of 2024, I was having repeated episodes of blood sugar going really high or going really low. And I passed out actually twice at my job and was put on probation because of that. My employer is very concerned about liability, and ultimately I was kind of asked to leave. Since that time, I've continued to have trouble keeping my blood sugar under control. I have, my doctor advised me to lose weight. I've lost 15 pounds. Still need to lose more, but I'm trying. I used to smoke 3 or 4 cigarettes a day. I completely got rid of that. Don't do that anymore. I'm very careful with my diet, yet My insulin needs continue to increase. My A1C remains out of control. And on average, and I kept a record of this, I'm having 3 to 5 low blood sugar hypoglycemic episodes in a month. And when it happens, if I am by myself, I pass out. And I've always kind of keep candy with me to address that problem. But sometimes it happens so fast I can't, get sugar in me to help me recover. And I've found myself on the floor 2 or 3 times. In fact, my spouse or my brother, will call me, once a week, every day, just to ask me to confirm I'm okay. And I've got a life alert and all these other things. And then I'll also tell you, Judge, that, 5 to 7 times, my blood sugar goes into the 500 range. And while that's something I can, I see when it's happening, I'm on an insulin pump, I can give myself an extra boost. It does make me very shaky and unable to focus and concentrate for about 2 or 3 hours. This happens regardless of what I eat, regardless of what I do. It seems to be worse in hot weather, and you're telling a story. In other words, we human beings are creatures of narrative. We like stories. That's why you have novelists that write books. So if you sort of tell a story and you tell it from the perspective of, I am a hardworking, honest person. I hate the idea of filing for disability. I'm only doing it because I have no other choice. But here's what's happened to me. Here's this medical problem. Now, I've done everything the doctors have told me. I've undergone procedures. I've undergone surgery. But I've done things to help myself. I've stopped smoking. Big deal, by the way. Judges hate people who smoke because it complicates so many things. I've lost weight, another thing that's really important. I've changed my diet. Shows you're taking an effort, making an effort to improve yourself. Despite all these things, my condition gets worse. The medicines I've been given lose effectiveness. I've been on 5 different types of mental health medications, but it still doesn't help me. I've been on 10 different migraine medications. They don't work, or they work for a little while, then they stop working. And I start having side effects or whatever. You're telling a story. And so you want to quantify those things as much as possible in terms of how frequently it happens. How is it once a month? Is it once a week? What you do to recover, how long it takes you to recover, side effects of medications. You're just painting a picture, because the story you're telling is, despite my best efforts and my desire to work, I wouldn't be a reliable employee at a simple entry level, warm body, fog a mirror type of job. And that's the story you got to tell. So, if you, ask, let's say, Perplexity or ChatGPT or Claude or AI tool to help you frame that, given some information you could give it, that wouldn't be a bad thing to do. Otherwise, just kind of sketch out a story. If you've got an attorney, talk to your attorney about it. If you don't, talk to a friend. It's got to be a fairly brief statement, 2 or 3 minutes at most, but you're basically laying out the groundwork as to why you wouldn't be able to work. And that's the main story. You don't want to get bogged down in the details, about you went for 3 MRIs and they canceled 2 of them because, there was a strike at the railroad. People get into the exhaustive detail about things, or, my knee moved and they had to come back, or the technician was having a bad day. And, I don't get into that. Just go into what's the most essential things. You don't need to get into, my doctor never liked me, and, the pharmacy was incompetent. People will go into this, they'll start talking. Judges don't want to hear that. They just want to know why you can't work, despite your desire to do so. So I think that's why they are, that's why you have to kind of be able to make it very, very brief, but tell your story in a believable way, where you're just very, very matter of fact, but regretful that this has happened to you. And your desire and your hope that you'll express is that you'll be able to go back to work someday. That's what you really want. It's rewarding to you, not just financially, but also you're interacting with people. And you can talk a little bit about, just briefly, Judge, since I stopped working, it's downright lonely. I mean, like my friends were at work. I feel like I'm less of a person. My family doesn't respect me. Financially, it's been devastating to my family. But, this is not something I'd wish my worst enemy. This is terrible. But right now, I just need some time, to get my health back, and I'm back to work. But I need to get to the doctor, get perhaps a procedure. And that's what I'm hoping to do with this. I don't see this as a permanent state of affairs. That puts you in the best possible light with the judge, in my view. But don't hesitate to ask for some help. But again, be very specific, be detailed, but focus on the story at hand. Kathy Clayton, yes, I hear you, Kathy. I know typing, especially on a phone, can be very, very difficult. If I presented Itzlin, if I presented to be too well, my therapist reviewed, then my doctor agrees I cannot work. Okay, I think what you're asking is if you come across that you're doing really well with your therapist, is that going to be a problem? And then I'm not sure what the doctor agrees you can't work. Well, I think what you're getting at is, if you look like you're really healthy, if you're improving, is that going to hurt your case? I think that's the wrong question to ask. I mean, again, as I just was reminded of the last question, the goal here is to present yourself in a way that you come across as someone who wants to go back to work. If therapy, mental health therapy, or medical treatment has been successful, then tell the judge it's been successful, that you're hoping to go back to work. And, you'd be open, and again, with your attorney's discussion and agreement, you'd be open to a closed period, that you during this period of time you couldn't work. But, you're open to that, or you understand that the judges put reviews on people. No problem putting a year review on this, because I'm expecting to be back at work. And if I go back to work, you have the 9-month trial work period, all that. So I think just address the bull by the horns. I mean, take the bull by the horns and just address it as if, okay, I'm getting better, and that's great. I think this is a real positive. I've told this story before, but, if you have a medical condition that was really bothersome when you apply, but it's gotten better now, and you tell the judge, let's take it off the table. I used to have digestive issues. I don't have them anymore. I used to have left shoulder problems. Don't have them anymore. Let's take it off the table. Judges are so shocked by that they'll, all of a sudden, your credibility goes through the roof. So, judges are people. And again, you're telling a story and you want to make it believable. If you go in and say, Judge, my pain level's on a 10-point scale, it's at an 11. It's at a 10 all the time. I'm in excruciating pain all the time. I can't walk for more than 5 minutes. I'm back in a recliner. I'm in a recliner 23 hours a day. I can't sleep in the bed. I'm in a recliner 23 hours a day. The only time I get up is to go to the bathroom or to get a slice of toast. I can't cook anything. I'm just completely unable to function at all. I'll walk outside for 5 minutes and that's pretty much it. I can't lift more than a pound or two. And maybe that's true. Okay. And if there's medical evidence, God bless you. But most of the time, that judges are going to see that as an exaggeration. Like I had a case like this a few months ago. Despite my preparation, my client's like, the judge says, how much can you lift? Oh, about a pound. The judge says, are you sure? You don't want to revisit that? A pound. Oh, just a pound. Well, a pound is like nothing. I mean, it's barely more than your cell phone. It's just not, unless you are that fragile that you can't even hardly lift your cell phone up, you can lift a pound. Most people, if you're a woman and you've got a purse, I guess a man could have a purse too, that's going to be maybe a couple of pounds. I mean, a couple of bottles of water could be a pound. So, he just didn't come across as credible. Judges didn't believe him. And, about other people, how long can you walk? Oh, I can only walk about, 10 feet. Yeah. Okay, if there's medical evidence shows 5 herniated discs and, numbness, from the top of your hip to the bottom of your foot, fine. But if you've got, maybe a one herniated disc without nerve root compression or a bulging disc, judge is going to believe you have pain, but not a level of pain that is way in excess of what the medical evidence shows. So, I just think you have to really be aware that judges have seen everything. They've seen, most judges have been around for a while. They've seen people out faking it. They've seen people exaggerating. They know in their own mind what a person with a herniated disc and nerve root compression what those limit, how that's going to be limiting. They also know what a bulging disc with no nerve compression, what that testimony should sound like. So just tell the truth. I mean, I think that's just the best way to do it. Tell the truth, but don't try to put on a show for your therapist or doctor. It'll always backfire. Kevin says, how much harder is it going to be to get SSDI? Well, nothing in the pipeline right now. I know that the one thing that we had been really concerned about was the grid rules. There have had some discussion about eliminating the grid rules, and that keeps popping back up. Nothing has happened. Some of my colleagues are of the opinion that that's the next most likely thing to happen. It would be really a problem. And the reason for that is that the grid rules basically make it easier for people over 50, especially over 55, to win, because it reflects Social Security's understanding that people over 50 with a chronic medical problem are going to have a hard time finding work, which just kind of makes sense. If you get rid of the grid rules, a person who's 58 is going to be treated the same way as a person who's 28. That makes no sense. I think obviously people who are 58, are going to have a really hard time, A, learning new stuff to take a new job, and B, convincing somebody to hire them with a chronic medical problem. So again, some of my colleagues are telling folks, look, if you think this is likely to happen and you've been kind of holding off keeping your job so you can, avoid filing for disability, maybe the time is to do this before the grid rule changes comes about. Now, if they do change it, we don't know whether it would be retroactive to a certain date. Now, there's a lot of times they'll make a change like that, like they did the certain rules they did about, let's say, the treating source opinion. Cases decided before a certain date use the old rule. Cases after a certain date use the new rule. Or could be these cases are filed, but it also could be that as of, pick a date, March 31 of 2027, hearings decided after that date, there'll be no more grid rule argument. That would be a real problem. So if that's possible that could happen, I would tell somebody on the fence, go ahead and file it now. We don't know. Every time that's been brought up, the grid rule thing has been shot down. But, we don't know what the new Congress is going to look like. There's a lot of unknown factors. So I think that there is certainly risk. I think that, the trust fund insolvency is coming up next few years, and they're going to continue to look for ways to reduce the outflow. One of those will be making it more difficult to win disability benefits. On the other hand, anytime the word Social Security is mentioned, there are probably 50 people at AARP who get pinged, and they immediately start calling in favors. So AARP in particular is their main purpose in existence is to protect Social Security. Even though disability is not really their main thing, their concern, and I think it's a legitimate one, is if the current administration or the government or Social Security itself decides to make changes to the rules about disability, the next thing they're going to go for is retirement. So, I think that the AARP would probably be of help, but, these rules could change. And again, if they do, it's going to be a lot harder to win. Not impossible, but a lot harder to win. Although, let me say this, I talk a lot about the grid rules. And if you don't know what I'm talking about, let me put this on the screen here. I've got a website called gridrules.net, and you can go there. Oh, wait a minute. I put that up there before. Okay. Grid rules, yes, gridrules.net. And basically I talk about how it works. And if you know what that is basically people over 50, it changes the definition of disability. So even if you could do sit down work over 50 or light work, which is lifting 20 pounds and standing 6 hours over 55, you're still disabled. So it means you could do a lot of jobs technically, but still be disabled, because Social Security realizes that most of the light and sit down jobs are not going to be available to a 57-year-old with chronic back issues and not really any transferable skills. That's the concept there. So my point here is that when I'm looking at decisions where I've got clients who are 57 with these things, and in my brief I make a grid rule argument, what the judges usually do in their decisions would be something like, I've made it come to the conclusion this person's functional capacity has been so reduced by pain, by, you know, uh, um, by spinal issues, by medications, whatever it may be, that there's no work this person can do. However, in the alternative, even if that argument is not accepted or is overstated, the grid rules will leave that person disabled. So in hearing decisions, grid rules are always kind of described by judges as kind of a secondary problem or secondary argument, which is kind of interesting. Every once in a while, it'll be the main argument, but usually it's a secondary argument. So I say that because what that says to me is that judges wouldn't necessarily change the way they make decisions, because if the grid rules go away, it just would eliminate that backup argument. But they're still making decisions under a functional capacity theory, which I always thought was very, very interesting, that they don't really go to the grid rules right away, but they don't. So it may be that if they got rid of the grid rules, it could be just a big nothing burger and nothing really changes, but I hope we don't find out. Yay says, should my doctor submit a mental capacity form? I had her fill it out and send it to SSDI. I think if the doctor's willing to do that, it's always helpful because it translates specific medical or mental health issues into work limitations. The question is, did the doctor put something on the form that's going to help you? And the problem is, under the law, if it's available and you know about it, you got to submit it. So if the doctor wrote down that, yay, it's ZLN, I'm assuming your initials are ZLN or LN. So assuming LN, you have significant medical issues, and the doctor writes on there that, oh, Ellen is perfectly maybe you're Ellen, maybe your name is Ellen, maybe that's what it is. Maybe that Ellen is perfectly healthy, has no back issues at all, and is perfectly mentally capable of doing complex work. It's going to hurt your case, So, like you always hear about lawyers, never ask a question you don't know the answer to. Before I would give the form to the doctor, say, what are you going to help me here? What is your take on this? And if the doctor's like, well, I can't say that there's anything substantially wrong with you, then, okay, well, doctor, there's no need to do this. I don't think that's a problem. But if the doctor does it and you read it and it's like, this doesn't help me, you can't rip it up. So that's where you gotta be careful. All right, Kevin, one at 60 years old. I think you were asking maybe about reviews before. But yes, 60 is a nice break point because it, again, helps with the grid rules and the transferable skills analysis. Dolphin, one at 56 years old. Okay, and you were approved almost a year and a half after onset. Okay, fully favorable. That's I love those. I love getting them. That's something I have a little utility. I always check to see. Like, I'll check now. Nobody knew, but I'm looking here. I got my last, let's see, 7. I got favorable. I got an unfavorable, which is a client who really did not help himself. Should have been a winning case, and he just did not a good job in testimony, in my opinion. Favorable, unfavorable, favorable, 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 favorable. So I've got a bunch of them in a row that are favorable. You're not going to win them all, but I have a good staff. They prepare them properly. I'm good at choosing good cases. And I've got a couple here unfavorable we're appealing because we think that the judge was wrong. 83, the Casanova, is going to school, taking classes, an issue. It can be, because you could argue, or Society could argue, that taking classes is SGA, substantial gainful activity. If you're going to class, even if it's at home, taking college classes is a mentally demanding kind of thing, which says that if you had a job where you have, some, I wouldn't call them, complex mental tasks, but, you've got to make decisions, you've got to multitask, you're able to go to college, then why couldn't you do that? So mentally, if that's the case, it could hurt you. And if physically you're going to class, you're sitting there, presumably for a few hours at a time. If you're taking 3 or 4 classes and you're spending, 6, 7, 8 hours a day between going to class and studying or doing your homework, that sort of sounds like it's equivalent to a job. So that's where you run into trouble. You're taking one class that meets once a week or twice a week for an hour and a half. You're doing it from your home with a sit stand option and a big rubber donut, under your behind. Different story. But you still have to get past the cognitive ability to do it. Again, you're trying to better yourself. I admire that. But you don't want these going to school to kind of look like it's equivalent to a job. That's where you got to be careful about. And that's where they try to get you into CDR. Is they'll say, you're going to school, that's like working. Why do we need to pay you? Yep, I think, you should always appeal at least the administrative level. And if at a hearing, if you lose at a hearing, you got a bad judge, you got an unreasonable judge, appeal it, low approval judge. I mean, there's some judges that I know I'm going to appeal every single time because they're 30% approval rate. So it's just the way it goes. Okay. Sunshine says that at one point he was told, or she was told, that he needed a physical CE, consultative evaluation. Today, Social Security called and says you may not need it, or maybe that he's going to let Social Security know you're on a feeding tube, you're 60 years old, grid rule, feeding tube, very, very sick. Most people don't have feeding tubes, very, very weak. And assuming that this has been going on for long enough to get it back to your onset date, if I was representing you, I'd contact the adjudicator and say, I got a 60-year-old in a feeding tube. Why are we wasting our time with this? Let's get this case approved. And that's maybe what your attorney is doing, and hopefully looks like being effective at doing it. Shub and I have an ongoing discussion about, I think you're a Philly fan, and I'm a Braves fan. The Braves have been doing pretty well this year, although the last month was a bit of a slump. And they got killed today by Pittsburgh, I think, like 10-1 or something like that. So I don't know. It's all about pitching. And back in the day, the Braves had the best pitching. They had, just a great pitching coach, Leo Mazzoni, and they had obviously Smoltz and Glavine and Maddox and Avery and Merker. They had some really good pitchers. I think the baseball has changed a lot. It's a lot about how hard you can throw. There's obviously, there's strike zone cameras, so the umpires are less important. It's changed. There's pitchers don't bat anymore. There's a designated hitter. So, I think there's more parity in the leagues. Obviously, scouting has gotten better. It's a fun sports to watch. I grew up playing baseball, watching baseball. But they've changed. It was pitch counts, so now the games run 2 hours instead of 3 hours. But I think a good, well-played baseball game is really kind of fun to watch. There's a kind of poetry to it. We're going in the World Cup right now when I'm recording this, and there are matches here in Atlanta and there are matches in the U.S. I just was never a big soccer fan. I admire the athleticism. I've been to Atlanta United games, and you appreciate how great these athletes are. But because I never played it, I don't really have a real appreciation for the skills that are involved. So people will go crazy over a 1-0 game or a 4-1 game, and it's like, okay, 4-1, big deal. But so I don't appreciate it the way I know many other people do. But I do admire the athleticism of these guys, how great they are, and when the women play the same. It'll be interesting to see if my grandkids play soccer or tennis. We're probably going to push them towards tennis because we all play, or baseball. But I know when my kids were young, they all played soccer just because it was easier for a young kid to be coordinated in soccer. So we'll see. But I never played it or much at all growing up. Any thoughts how the decision may go? Well, again, if what your question before was that your lawyer said we may not need the CE. Now, is that because somebody called your lawyer? Is that because your lawyer is going to call somebody? So I don't have all the details I would need to answer that question. But, you've got it sounds like a pretty compelling argument for disability. Okay. Unless it's really necessary to work on SSD as a risk to work, even if compliant with SSD's requirement. I think there's an argument to be made there. What Hakasad is getting at is that let me change the banner here, go back to my normal one. I'll put this one up there for a second. It's about reviews. The Social Security rules about working are very complex, unnecessarily complex. First, you've got something called a trial work period, which you can work up to a certain amount. I think it's $1,100, $1,160, and it changes every year. And you have 9 of those months before it becomes a problem. And you could earn $1 million a month, gross earnings, and it wouldn't affect your benefits. And after that, then as long as you stay below SGA, which is $1,690 a month, you should be okay. The problem is that there's no way to see where you're at in real time. So you may, the trial work period runs over a 5-year rolling window. So you work 2 months in 25, and you work 3 months in 26, and 4 months in 27. You may use up your trial work period months and go over SGA and get into overpay status and have no idea. And then, you're in overpay status, and you don't know that just because you don't even know. And all of a sudden you get a letter in the mail from Social Security. We've decided you've been overpaid $30,000. Here's an envelope. Send it back to us by then in close of business next Friday. And that's what happens. So, some people say they make it so confusing. I don't want to bother. I want to take the risk. And so I think that's the what Hakasad is saying. Yeah, I think if you're really careful, what I tell my clients is, if you want to work, learn. Let's go over the trial work period and the SGA limits so you kind of know. But if you want to be safe, either keep it below trial work, because if you're under trial work, then that's not going to trigger any kind of review. If you're willing to take a little more risk and possibly trigger a review by using up your trial work period months, stay under SGA. Don't go over $1,500 a month, and you shouldn't have a problem. It's just how much risk you want to take. That's really what it kind of comes down to. Ellen, I'm guessing, yay, it's Ellen, that your name is Ellen. Tell me if I'm right. I'm going to call you Ellen. But you tell me if my guess, if I interpreted your moniker here correctly. Had a Social Security doctor's appointment for mental health in April of 25, and unfortunately I presented well. It was a clear-headed day. They decided I'm well enough. I'm at the hearing stage. What I would do is on Form 795, I would draft a statement explaining why, you presented the way you presented. That, this is an unusual day, that most days are not like this. Your attorney can help you write it. But that, the way you presented on this day in April 2025 is atypical. And those kind of days happen, 3 or 4 times a month. The rest of the time, much less so. And if you've got other medical records, mental health records to kind of corroborate that'll help. But that's how I would deal with that. Okay. And again, I think we talked about this, that, if your doctor's willing to submit it and it's supportive, if it exists, you got to submit it. But if you're asking about getting one done and you confirm it's going to be supportive, then by all means, that'll probably carry more weight because it's from a treating doctor. Is there a status update in the back to just hit the account? In my experience, just hits the account. Normally, they send you a letter around the same time it hits the account where they describe the payment. Called notice of award, and they'll send it to you. It'll kind of spell it out. Then you'll typically see the money showing up a few days after that. Should you complete your CDR packet as well as online and in writing, I guess, to be safe, or is online enough? They're all paperless. I would do it online, but I would say what I would do is I would print out every page, and then when you get a comment at the end, it'll say confirmed, received. Print that out. Just print it out so you got proof of it. But I think online is sufficient. Hello, sir. Hello, J3. I'm 51 years old and filled out Form 455. That's a continuing review. You wait for them to give you a decision. That's all. Just wait. Nothing you can do. Can you own businesses one SDI? Here it's going to come down to, what are you doing in the business? If it's a passive investment, you're not doing anything, but your name is, as the owner of the business, but your son or your brother is doing all the work, you're not doing anything. They're going to look at what you're actually doing. On the other hand, I've had this pop up a couple of times. Why would your brother put his business in your name? Doesn't make a lot of sense, right? So I think that's the real question here. But I think, owning a business, they're going to assume, Social Security will assume you're doing work for that business. If you're not, you need to be able to explain that. This is an excellent question. So this is going back to the CDRs. If you decided to continue to take benefits and you lose, do you have to pay those benefits back? Yeah, you would. And that is one of the issues that you face. Let me see if this changes anything. I was looking at myself on the screen. I look kind of orange here. Let's see if I can look a little less orange. Is that a little better? I don't know. I don't know what I look like, but I look less orange there. Okay. But yeah, to answer your question, theoretically, yes, you'd have to pay it back. Now you could bankrupt on it. You could ask for a waiver, but you would have to pay it back. Okay, here. Born to Shop. Just filed today. Worried I may lose my car waiting on them. Nothing I can do, it seems. No, unfortunately, you really can't. I mean, I think if you are, there we go. I'm just playing with the exposure here to get myself to look a little more natural. I just look really weird from my perspective here. I don't know if you guys think that or not, but okay. I mean, it could take a couple of years, and you could lose your car, lose your house. People, talk about that all the time. It's difficult. Nothing you can really do. I mean, you could make your dire need, but I don't know how well that works anymore. Hello, Chloe. How are you doing? Baxter, April, I was fine. May shows heart attack. Again, I don't think it would be a problem to do that, to show that, this is the difference. It's not going to be as compelling as what happened after May, but yeah, I don't think that's a problem to submit it. Michelle, thank you for your help. You're welcome, Michelle. Multiple conditions, better tell them about the main few to keep it simple. I think that's a very astute question. I would put the main 3 or 4 in. You can add in the others that in addition to these main 4, I have additional complications, and list them so that you've notified them. But I think I would focus on the main 3 or 4, the ones that are most disabling, and ideally the ones with objective evidence behind it. Sean Hamburg, what happens if you're on permanent restriction, 10-pound of bending or twisting? Well, if you are 55 years old, that's a good sign. If you're even 50 years old, that's a good sign. It may be that you meet the grid rule. Otherwise, if you're 35 years old, a 10-pound lifting restriction with no bending and twisting will not disable you from every job. So you're going to have to find other things going on. But it's a start. It's a good start. Forge Mill family. Hypothetical. Okay. If you have been on FMLA for 12 months and are able to return to work, what will be the onset? The onset day would be the last day you actually worked. FMLA is not work. So the last day you physically went in. So if you went in physically, the last day was June 30th of 2025, that's your onset date. Or even to be more specific, it's the last date you're able to function effectively at work. If you're still getting paid full time, maybe you can squeeze another couple of weeks, or maybe push it back so you get 1 more month of past due benefit by saying the last 2 or 3 weeks I was not doing the job as it was as described and as by required, and so I was getting a lot of help, and so I'm going to use May 10th of 2025, even though I did not formally go on FMLA until June 30th. As of May 10th, I was not doing the job in the way it was supposed to be done, the way I was hired to do it, where I was being paid for. My coworkers were helping me, my boss was helping me, and that may get you that extra couple of months. But I don't think you go past a couple of months for that. All right, Chloe asks, many people with autoimmune diseases tell us they have good days and bad days. From a legal standpoint, what's the best way for someone to demonstrate they can't sustain full-time work? I think with good days and bad days, one thing you can do is keep a calendar. Just go to a drugstore and get a calendar and write down when you're having a good day or a bad day or a good half day or bad half day, and kind of describe what makes it a bad day. I'm in, I'm autoimmune condition. I'm itchy all over. I have terrible, drawing pain. I can't, you know, focus and concentrate. Whatever the symptoms might be, you want to describe those symptoms, but keep a record of it so that 2 years down the road, we have a hearing, we walk in there with a spreadsheet showing this is from your calendar, maybe even update our calendar of good days and bad days. And you statistically, Judge, you can see, I would say on behalf of my client, Your Honor, as you can see, my client had an average of, 10 good days every month. The rest of them were bad days. And here's some selected quotes from her calendar about the bad days, what they were like. That's how you show that your bad days are frequent enough to make you not reliable at work. And it may only require, 7 bad days a month, because you realize Social Security judges, if you say I got 3 bad days, well, that could be on weekends. So it doesn't really hurt us, does it? But if you like 7, okay, it's going to be likely there's going to be some during the week. You can talk about what triggers it. It could be the weather, it could be the cold, things out of your control. But I think that could be medication. I've seen people have really bad days after certain infusions. So I think I would just keep a calendar and document it all. That's really the best way to deal with that. For someone over 60 who's thinking about filing for SSD, what's the biggest strategic mistake you see before they even submit an application? Well, if you're over 60, unless you absolutely have no physical issues whatsoever, I would venture to say most people over 60 have some physical limitation. It could be just arthritis. It could be some pain in their back. But I think that, many people, not maybe, I would say most people over 60 are going to have a hard time doing a medium job. Medium job is lifting 50 pounds an occasion, 25 pounds frequently, standing and walking 6 hours a day. I think a lot of 60-year-olds are going to have trouble with that. And so if you've got just some mild to moderate back pain that would keep you from doing that level of physical activity, or you had to give up golf because you have back spasms, or you can't drive for more than 20 minutes without having to stop, add the physical part in there. That brings the grid rules into play, and the grid rules give you a much greater argument for winning disabilities. I think that's one thing that's really important, is if you're over 60, to try to make an argument for physical. Could be the back, could be the knees, elbows, shoulders, ankles, wrists, things like that. But I think that you really want to bring the grid rules in if you possibly can. I think the second thing, of course, in any disability case, is to be as specific as you possibly can. Talk about specifically why you're not able to work. If it's physical, what your limitations are, and really think about those limitations and realize that, every job has a certain level of physicality to it. Don't overestimate what you can do. Men in particular, we like to think of ourselves as, I'm in a 60-year-old body, but I'm still 25 in my mind. I could lift 75 pounds easily. Really? You think you could lift 75 pounds easily? I don't think so. You have a bulging disc. No, you can't. You're going to hurt yourself. So I think you have to be realistic with yourself, really think about those things, and be prepared to talk about them in your application, about those things you can do. If it's mental, again, same thing. Talk to friends, people that you deal with. Ask them about, are you difficult to get along with? Are you moody? Do you tend to forget things? Do you lose track of time? You have trouble following instructions? And those are the sort of things you just got to be very, very specific, but you got to be realistic. So again, I think bring in the grid rules if you can. And I think secondly, be realistic about your limitations, as uncomfortable and unpleasant as it may be to look yourself in the mirror and say, you know what, I can't do these things anymore. It's really hard to do, but you got to do it. Got to do it. Okay, we already talked about that one. Does SSDI convert to SS retirement at 62? No, it's 67. It does not convert at 62 because why would you do that? I mean, your SSDI is equal to your full retirement. At 62 is early retirement. So no, you would never convert it. Let it go to full retirement. If you converted to Social Security from SSDI at 62, which I don't know why you do that, and you work with your SS reduced, would your retirement be reduced, $1 for every $2 after 24? Yes, that's why you would never do it. I can't think of a scenario why I would tell somebody to convert it to early retirement. You have your trial work period months. You could do your below SGA earnings. You're probably not going to get reviewed at that age. I think you're much better off just, working under SGA and keeping your full benefit than you would be, converting to retirement at 62. Maybe there's a math scenario that I'm missing where it makes sense if you're earning 24,000. I mean, again, it could be. I've not done the math, but I mean, generally speaking, I think that would not be a good idea. For someone who's 64 and been on SSDI, what are the chances of getting a CDR if I got a part-time job making $1,300 a month? I would say little to none. You're not the target. At 64, you're close to retirement age. By the time they got around to taking you to a hearing, you'll be at retirement age. Just no reason they're going to review you. I think CDRs are really most risky for people under 50, but over 60, almost never. Could that change now they've moved everything to a federal office? Could change, but not likely, in my view. Sorry about that. You talk for a couple hours and your throat gets a little dry here. Okay. Mbisan. Good evening. I'm a 46-year-old, 100% disabled veteran. Thank you for your service. Also in FERS, disability retirement due to my inability to concentrate, depression, PTSD. Recently denied your ALJ case. I would say look at it for appeal. If you're within 60 days, have an appellate lawyer like Carl Osterhout or Brian Konoski look at it and give you an opinion as to whether they think you have grounds for appeal. 46 is hard. Look, it's hard. On mental health is hard. So I think those are things that are working against you. But of course, you're still insured, I'm guessing, which is why you're doing this. Realize that with FERS, if you did get approved, FERS has a unique little trap you got to be real careful about. If you know what FERS is, it's federal disability retirement, as Mbisan said. But if you get approved, the first year, the amount of money that you get from Social Security offsets, or the FERS offsets your Social Security, but it doesn't. Let me back it up. If you get approved for Social Security, FERS says, we want you to pay us back what you got from Social Security for that first year, 100%. So if you got a past due benefit award and it amounted to, let's pick a number, $17,500. Okay. FERS is going to say, we want that $17,500. The trap is that if some of that money went to pay your lawyer, FERS doesn't care. They say, that's between you and your lawyer. You got to pay us the full amount. So you're getting money, okay, that's already been reduced because Social Security's already reduced your benefit by, so let's say in a $17,500, let's say that's your whole past due benefit for year one. That's all we're talking about. $17,500 times 0.25, that's $4,375. So $4,375 gets sent to your lawyer. So 17,500 and 4,375. You're going to get a deposit of $13,125. But FERS wants $17,500 back. You didn't get that money. You never saw it. It went to your lawyer. But FERS wants it back. That's a problem, right? Because you're paying back money you never got. Now, the second year, I think it's a 60%. Then after that goes away. So you just got to be aware that FERS makes things a little more complicated in that regard, because they do have this, overpayment situation where they don't account for attorney's fees. It's kind of dirty pool, in my opinion, but that's the way the law was written. Okay. The judge spoke that my disability is severe. Well, severe is a term of art in the disability world. It simply means that you've got a severe problem. It's a diagnosed medical problem that could have some impact on your work capacity. Doesn't mean that it's disabling. It just means it's something that's going to be considered, versus non-severe means there's no evidence really at all to support it. So you could have PTSD that's severe, but it's not disabling. It's just severe, means it's a legitimate complaint. That's maybe the best way to put it. Severe in Social Security terminology is it's a legitimate complaint with some medical there, but that's all that means. The VE says I don't qualify for work due to time off task. Well, again, the VE probably asked multiple questions. It was asked multiple questions, and one of them was probably from your lawyer that said if MB-San was off task 15% of the day, would they rework? The answer is going to be no. But if the judge and the doctor, said you could, but if the judge doesn't accept your doctor's opinion, and the judge chose a different hypothetical than the one with the off-task time, and the judge acknowledged your limitations are severe but not disabling, are you going to win? You got to prove that you have disabling levels of impairment, and or that your attorney's hypothetical question is really the more reflective of your RFC than what the judge did. I would have somebody look at it. Yeah, I would have, Carl Osterhout look at it, Charles Martin look at it. There's lawyers that, that do appellate work. That's all they do. And I would have somebody look at it and offer an opinion. It's whether they think it's worth appealing. Sean Hamburg says, I'm turning 60. Well, I have a birthday in July, actually this Saturday. I'm not going to tell you how old I am. You have to guess. But I have a birthday in July as well. Will it help my disability case? Well, yes and no. I mean, it obviously 60 is a threshold birthday for Social Security purposes, but you don't want a judge to approve you as of your 60th birthday. There'll be no past due benefits, or limited. So, is a fallback position, yeah, it's great to have a fallback. I'm 60, therefore that makes my disability easier to win. But I'd rather win with an onset date when you're 57 or 58, so you get 3 years of past due benefits. Does being 65 increase chances of SSD? Well, 65 is getting really close to retirement age, so anybody over 60 has a better shot at it, because Social Security realizes inherently that anybody over 60 is going to have a hard time finding a job or learning a new role. In fact, when there's in a transferability of skills analysis, over 60, there is a minimal vocational adjustment standard applied to a transferability of skills analysis. So yes, it's easier to win if you're over 60. The problem from my perspective is if somebody's 65 and they're getting early retirement already and they want to get disability, the difference between what they're getting at early retirement versus what they would get at full retirement, maybe $100 a month. I'm not going to take a case where my recovery might be $350 or $400. It's just not worth it. So it can be hard to get an attorney when you're that close to full retirement age. Nervous about a remand. Yeah, no, I hear you. But if you go to appeals, that's what you're hoping for, is a remand. So what are you going to do? That's look, this is a long-term prospect, long-term deal with Social Security disability. It takes a really long time to get a decision. And yeah, it can be very frustrating, and it can be very nerve-wracking. I talked to a client, a pre-hearing call this week, and she said to me, I'm extremely nervous, very anxious about this. Like, we got a good case, but I get it. I mean, this is nerve wracking. I do this 3 or 4 times a week. I mean, so, I know what to expect. I know what I'm doing. I know many of the judges, but if you've never been through this, yeah, sure, it's nerve wracking. Just, again, practice with your attorney, be very specific and tell the truth. Don't exaggerate. And just, again, go with the attitude that you hate the idea of having to do this. That you are fighting it every step of the way. Born to shop is 57, a lot of medical issues, immune deficiency. How does that play into approvals? Certain things that don't count. Well, immune deficiency, again, let's talk about what that's going to do. Okay. I would think it would mean that you need to avoid being in crowds, probably avoid interacting with the general public, probably avoid direct contact with coworkers, minimal contact with supervisors. So that is a limitation, right? That's a functional limitation. Maybe you get sick more often because you've got an immune deficiency. So, if you have evidence to show that you are constantly getting colds and constantly take off, or that your colds, turn into pneumonia 3 or 4 times a year because you can't fight it off, that could be an issue. Or you develop hives, or you develop other complications of infection from the immune deficiency, or you've got to take infusions. All of these things start to chip away at your reliability. Really focus on reliability factors. What about your immune deficiency makes you not reliable? Could be treatment frequency or intensity, or how you feel after that, the degree of sickness you experience, how limited you are in interacting with other people. That could be a factor. There's just a lot of different things that come into play. As far as things that really don't count, I'll just make this more general as opposed to an immune deficiency case. I think things like scars doesn't affect your functioning unless you're a model, let's say. But even people with customer-facing jobs, if they've got scarring, that's not going to prevent them. They may feel self-conscious about it, but that's not going to prevent them from functionally doing the job. So things like that, I would say, conditions where you need, let's say, to go to a chiropractor or a therapist once a week, they're going to assume you can do it during your lunch break or after hours. Other conditions don't really move the meter. Sleep apnea doesn't really move the meter. Even if it's severe, it's got to be unbelievably severe to have a real impact on things. Those are just some things that really just don't really move the meter. They're just fibromyalgia. If you're a male, never win those cases. They just don't approve them. Certain PTSD, Social Security tends to minimize it. It's unfortunate because, they expect if you're claiming PTSD, it's something that happened to you. It's really hard to win a PTSD case because you were next to somebody. I remember I had a case years ago. My client was sitting at a desk, and her boss's former spouse or something comes in, it was a woman, and the man comes in and literally pulls out a gun and blows away the boss. My client's sitting there 5 feet away, and the guy calmly walks out. And she's like, I've had nightmares about this ever since for obvious reasons. Very traumatic. Some guy walks in with a gun, blows away your supervisor, your coworker, and maybe even points the gun at you and laughs, then walks away. That's pretty compelling. Judge is like, it's bad, but it didn't happen to her. It wasn't like she got pistol whipped or anything like that, and just felt like she should be able to get over it. I've had people in the military talk about they're on a Humvee or a troop carrier, and an IED explodes and the guy next to him gets killed. They were not. The guy, we were on patrol, and we had to shoot a 10-year-old. It looked like they were going to attack us. Stuff that would just give us nightmares. But Social Security just, that's not enough. In my experience, I think it's ridiculous. I've had several cases, which really bothers me, quite frankly, a number of female soldiers who were sexually assaulted or abused or intimidated in the military by direct supervisors. and the military just covers it up and promotes or moves the person who did it away, and maybe doesn't promote the victim, won't give them any kind of help. Judges, for some reason, not every judge, but many judges, like, well, that's not enough. That's not enough. They don't necessarily believe that it was non-consensual. I mean, it's crazy, but for some reason, sexual assault of females in the military, this rarely moves the meter. Something, especially something that happened over a year and a half, because the judges, I think, well, it was consensual, and maybe now she's saying it's not. I mean, who knows? But it's just those things. So there are just certain conditions and certain scenarios that just don't really move the meter. But sleep apnea is one. Skin issues tend to not really move the meter too much. There's just certain conditions that just don't really resonate with judges. I don't know why. Here's another. I mean, hearing loss with auditory processing disorder. It's got to be pretty severe. There are jobs out there that you can do with pretty bad hearing loss. You don't have to interact with anybody. You're just putting those ink pens in a box. I've not had a lot of success. And, in healthcare, but, they're going to say, it's great you're in healthcare, but you could be you could work in a widget factory. You're not saying, I mean, you have to prove more than you can't go back to your past work. You got to prove you can't do anything at all. And at 59, if you have no physical limitations, and your main issue is auditory processing, well, you could do, physically a light job or a medium job where you're working by yourself doing this one physical task over and over. But auditory processing disorder will eliminate past work, perhaps, but not everything else most of the time, unless it's severe to the point where you couldn't follow instructions or you'd be a danger to yourself or others, I'm thinking. Okay, hearing aids aren't working. I mean, there may be a listing on on hearing loss, but again, it's just, I've done this for 35 years. I just don't recall I've ever won a case on that alone. I just don't know that it's enough. Not that I don't think it should be and shouldn't be. It just, doesn't seem to move the meter. Big Taj, a normal file for SSI before or after SSDI. Normally you file them at the same time. I think SSDI is a more robust program, so I would file for that more so than SSI. You can always add the SSI, but I wouldn't, if you think you've qualified for both, file from both at the same time. And if you realize you do qualify for SSI after SSDI, get it filed immediately, because you're only eligible for SSI as of the date of your application. You live in the Panama City, Florida area, what percentage of judges? It's just, Tony, it's going to depend on the judge. There may be some statistics someplace about judges in that, area of the Panhandle, but it's going to depend on the judge you get. If you get a judge with an 85% approval rating and a judge with a 30% approval rating in the same office, you get Judge A, you win. You get Judge B, you lose. So I don't think that's a particularly bad area. It's just, it just depends on the judge. Okay. Hearing in Delaware is scheduled in September. ALJ is a 67. Okay. That's good. That's good. Let me see if I can, I'm looking at my September hearings, and let's see if, well, we got a bunch of them in September here. Okay, cool. That's good. That's what we wanted. That's what I want to see. I think that judges are all over the map, but 67% says to me that, judge is going to be very reasonable. So I think that's a good thing. That's a good thing. So yeah, my hearing next week with one of our other callers or viewers here has got a 66%, which is really, really good. So I look fine. I think I look like really like orange here. I don't know. I played around with the white balance here. Ooh, that doesn't look good. There we go. Maybe that'll give me a little more. That looks a little more realistic. If you know what white balance is that in a camera or video, there is, let's auto white balance it. Let's see, that looks probably a little bit better. every light source has a temperature in what is called Kelvin, Kelvin. And I'm using movie lights, fluorescent movie lights, which are, I think, Kelvin 5500. And so sometimes, but I've got one that's a 5,000. I've got the overhead one, it's a 5,000. It's a different brand. I probably should just get them all the same, but I've got these flapjack lights, which are, and you can change it. The nice thing with these lights here, you can change it. So one of them here is 50. These are the two big ones are 5,500 Kelvin. But sometimes, depending on just the way the camera is done, or the camera sees it, it'll be too orange or too blue. And so you can mess around with it. And so I had it on manual white balance. And then I moved it to automatic, and you see it. When you see this now, you may see it look a little bit less orange in there. I'm a sort of a photographer, just amateur photographer, and white balance is a big deal in photography, still photography, because the difference in sunlight versus shade versus incandescent lights versus fluorescent lights can be huge. More information you want to know, I shoot in what is called RAW format, which means that I can adjust it after the fact, but it's better to adjust it in camera. But on this particular application with this video camera, which is actually a really nice, it's called YOLO Live video camera, it gives me a lot more control. And so I've really kind of enjoyed this and high definition and so forth. So anyway, I just was messing with the white balance to make myself look a little more natural. I'm actually using this camera, and this is a green screen, as you probably could tell. That's not my house in the background. I can change the look and feel there, but I've been using it for actually doing regular videos, regular YouTube videos. So I'm just having to fiddle with the lights to make myself look, to make it stand out a little more. So, and I got rid of most of the sort of the green, bleed through you get sometimes with green screens. So anyway, all right. So we've got a couple more minutes here. Are CDL drivers bound by FMCSA guidelines when they have a stroke? I'm not sure what FMCSA guidelines are. I'm sure what you're asking has to do with if you have a CDL, commercial driver's license, and you have a stroke, there's certain legal requirements before you're allowed to get back in the truck or commercial vehicle. And again, what that's going to impact in the Social Security context is your capacity to perform past work. Probably can get rid of past work. The question is, if you have a stroke and you recover, but you lose your CDL, does that mean you can't do other kind of work? Not necessarily. So, but it's going to probably get rid of past work. Eunice from Michigan, you are very, very welcome. Very, very welcome. I was in Michigan last summer. I was in, I can't know the place, but I was in Michigan. We have a regular Michigan viewer here, one of my clients, but I was up there. I'd never been. It was actually very, very nice. Okay, what is your recommendation for communication or much empathy with the person that's handling your case? Yeah, it's really hard to switch lawyers. Honestly, they make it really difficult because you get into fee petitions and things like that. I would start by trying to talk to a staff person and just say, because most of the communication you're going to have is going to be with your paralegal or case manager before you actually get to a hearing level. I think you just got to talk it out. I mean, it's hard because, there are this practice area is designed for systems, and you've got to have, if you do it in any kind of volume, if you do 1 or 2 cases a month or a year, okay, you could do it all yourself. But if you do, I'm doing 15, 20 a month. And if you're doing that many, which is not a ton, that's a relatively small practice, but if you're doing that or 50 or 100 cases a month, the attorney is going to be involved at the hearing level, typically not much before then, other than to problem solve. So you're going to have staff people, and, you need to establish a relationship with them, but don't, have your expectations realistic. I mean, this is an area you're not paying a lawyer by the hour, $450 an hour. You get 24/7 access and cell phone access. I wish it was the case. It just didn't. I'm just going to be straight up with you. You work within the system, try to establish a reasonable expectation for communication with the staff, with the lawyer, so you won't disappoint yourself. I've had people sometimes get upset with me, and you see, I'm on every week. I have clients that come on, they talk to me here. People email me, I'll respond to them. Do I get busy? Yes. If they call me on a Wednesday morning, I'm not going to get back to them until Thursday because I get the grandbabies. But the point here is that, somebody, and I've had clients like this that they want to call from me every single week, status update. Well, these cases, nothing happens for months at a time because Social Security doesn't do anything for months at a time. And I've had to actually tell people, look, you're better off with another lawyer. I can't call you every week. I just can't do it. There's just no time in the day, and there's nothing I'm going to be able to tell you anyway. So, having a realistic expectation as to what the communication will be, if you're at the early stages of your case and there's nothing for the lawyer to really talk to you about, your best interaction with the staff person, because your lawyer is not going to know. I mean, somebody called me out of the blue and said, okay, what was the last thing you uploaded to Social Security in my case? I have no idea. That's not what I do. You ask Kayana or Christy, they're going to know. That's what they do. So getting to the right person and not expecting the lawyer to be, at your beck and call every single minute of every single day. Like I said, if it was possible, many lawyers would love to do that. If you were getting paid $500 an hour, you do it. But this is not that kind of practice. And I think some people, it bothers them, and I get that. But, maybe there are lawyers who can do it, but it's really, really hard to do that. So I think I would just try to arrive at a understanding with your lawyer about what's reasonable in terms of communication. All right. I have Judge Peterson from Savannah. Well, 31% is not good. Let's look up Judge Peterson here. Well, this will be one of our last ones because we're over 2 hours at this point. Okay. Peterson. I don't see a Peterson. Let's see in Savannah. I don't see a Judge Peterson in Savannah. Oh, Craig Peterson. Okay. So I see a Craig Peterson in Savannah. What I'm showing here is his fully favorable rate is 26%, partially favorable 14%, for a total of 40%. 40% is at the low end of what I consider to be reasonable. 50% is kind of average nationally. 40 to 50% is you're within reason. Below 40%, it's starting to get a little iffy in my view. But when I'm seeing this ratio of 26 and 14, that says he's only approving 26% fully favorable, means he's changing onset dates. So what I would tell you is the risk you possibly run here is the judge will approve your case, but ask you to change the onset date. So I would talk to if this is the right person, that's a Craig Peterson in Savannah, who I don't know. But if your lawyer says that's who it is, and there is an onset date that could be changed, I would at least talk to your lawyer about it. Is it something we want to entertain and consider? Because that's what this judge is doing. He's changing onset dates to back off past due benefits. So that's what that means. Okay, Tammy, we have a hearing on September 24th. Do I know the judge yet? Let's see if I have a judge yet. We have a judge with a 53%, Judge Kwan, 53% approval rating, which is, again, a little bit better than average. So I could live with that. I could live with 53%. Anybody over 50% says they're reasonable. They're again, better than what, more than half the judges are like. So I'm okay with that. I'm okay with that. And what I will be doing is, your file has recently been worked up here. And so we just need to make sure, I'm looking just as a quick look here because we're running out of time. The most updated record I'm seeing here, Tammy, is from December of 25. So I'm going to dig into it, but before I do, I'm going to probably have Kayana and Christy update the file to get it a little more recent medical records. But I typically will start my briefs early, so I'll start working on it, and we'll be, it probably won't be till August before I start really digging into it, because we want to get the records updated. But I'm getting onto these earlier and earlier. So it'll be sometime in August. Would be my guess is that we'll start doing, you and I'll be talking on a regular basis at that point. Okay. Let me see. We got a bunch more questions here. Let me just take two more. I know there are a few people that I've asked that I'm not getting to, but I'm gonna just I gotta go. Gotta have. You can see my beauty sleep badly needed with a birthday coming up here. All right, Michelle says, "Is it better to have an attorney fill out the initial paperwork or do it myself? Get an attorney." I don't have a problem with somebody. I mean, I think that some people like to have an attorney do it because it just takes it off their plate. But if you can fill out a form, you know what? Do it yourself and avoid paying an attorney fee. If you can get paid, do it yourself. You don't pay that 25%. Go for it. Just watch some of my videos, learn what you can. Be very specific about your limitations. Stay away from things like not very much, not very far. Give it a shot. If you get turned down, call an attorney. But I mean, I don't think it's a problem to give it a shot on your own. I mean, unless you just really find the form very, very confusing. But most people, can get through the original form. And sometimes people will call me. They've filled out the form. Now they're getting all these other forms, and they're getting, consultative evaluations, and then I need somebody to help me. Okay, that's fine. But you know what? If you can get through it, the first part yourself, 35% of people that apply on their own win, or that apply initial, not on their own. 35% of initial applications are approved. Now, a lot of those are people with serious life-limiting conditions, but why not give it a shot? No reason not to if you feel comfortable doing it. So that's how I'd answer that question. Okay. Okay, we got that. Thank you, Ellen. Okay, what does Walter do? 20 videos a day lately. Walter not in Florida. I've actually I know I've emailed Walter. We've chatted maybe a couple of times. I don't know him. I've never met him in person. He's very prolific with the videos. I think he just has a camera by his desk, and he's very, off the cuff type of thing. And he shares what he knows. Like, I give the guy a ton of credit. I think that the more information you get out there, I mean, he shares what he knows. So he likes doing videos, and he gets them out there. I know he talks about things a little more peripheral at times. I mean, I know he talks about his student loans and his farm, things like that. But I got I think anybody who shares videos, Stephanie, Walter, Michael Liner, that's great. I mean, I think that what he's doing is awesome. And the more information out there, the better. And if you learn something from Walter or from Stephanie or from anybody else that helps you win your case, use it as a resource. Everybody's got their approach. Walter talks real fast, and I know he's got the thing where he's got a cell phone, and people call and he'll listen to their calls. And he just does it. It's got his style. That's cool. It's got his style. So good for him. Okay. Will this be a milestone birthday? Could be. I'm not going to say. Got to keep some of my secrets. But you're as young as you feel. That's my attitude. All right. Let me see. There's one more question I'm trying to get to. Okay. So Baxter Taylor says, "You familiar with Eric Fulcher in Macon, Georgia?" I've not been before Judge Fulcher. His rating I'm seeing is 54%, which is pretty good. Fully favorable, 40%, kind of low end of okay, and 14% partially, which again says to me he will not hesitate to change the onset date. So not the worst draw in the world, not the best draw in the world. Okay. I think you'll get a fair hearing, but don't know anything more about him. So that's all I can tell you based on those numbers. So anyway, all right. We are now at 2 hours and 9 minutes. So I am time for me to go. Got to take the dog for a quick walk, go to bed, and get up and do it all over tomorrow. So I hope everybody has a wonderful rest of your evening, wherever you are. A great weekend. Think of me on Saturday if you can. And I'll see you all next week. And I'm going to have coming up, I believe Jeff Herman from my buddy from Arizona is going to be on at some point in the next couple of weeks. And I'm going to a couple more surprise guests. But anyway, hope everybody's has a great rest of your day. Stay cool, and we'll see you next week. Take care. Bye. Bye-bye.